This is the Ray Appleton Show on News Talk 580 1059 KMJ.
As you may or may not know, but I think most of you know, here in the state of California, there has been a movement to do away with bail. Right. And not only would this leave a lot of bail bondsmen unemployed, but there's a great division as to whether this is the right or the wrong thing to do. The Supreme Court recently didn't do something which will have an impact on this issue of bail and its future in the state of California. Got a couple of people joining us on this one. On the phone, we have the executive director of the American Bail Coalition, and that's Jeff Clayton. Jeff, how you been?
I'm good. Thanks for having me on.
Hey, our pleasure. And here in the studios, my dear friend and fellow musician, defense attorney extraordinaire, who's talked about this before, Mark Capitan.
Hey, Ray. How you feeling, pal?
Better. But not 100% yet.
You look 100% when I looked in the window. You look great.
Thank you. The Supreme Court denied hearing a particular case, which meant they upheld the use of bail money and bail schedules. Jeff, talk about this. What does it mean to you? What does it mean to the state of California?
Well, I'm not sure yet. What it means to me is that the standing order in Calhoun, Georgia is constitutional, which allows for the use of a charge-based money bail schedule, presuming that there is a review of that bail within 48 hours. For California, what we're going to find out is whether the judge in the Buffett versus San Francisco case, a federal case challenging San Francisco's bail schedule, is going to reverse course, or whether she's going to go forward and go ahead and say the San Francisco bail schedule is unconstitutional.
And if indeed she says it's unconstitutional, what happens then? Where do we go from there?
Well, there's a possibility of that case going up to the Ninth Circuit, or there's another case out challenging the Sacramento bail schedule that could also apply the similar strict scrutiny standard that the Supreme Court rejected, and that would create a pathway for one of those two cases to go to the U.S. Supreme Court. I
mean, if indeed the legislators up in Sacramento got their way and did away with, bail in the state of California, not only do we have an economic problem of all those people in the business being unemployed, but what would be the legal path that we would have to pursue to do away with that possible legislation or that ruling that bail's a no-go in California?
Well, the California legislature has already tried, and we stopped them once from passing bail reform. Obviously, the only legal remedy, I think, if two federal judges are going to say that a bail schedule, we apply strict scrutiny under the Equal Protection Clause, that's going to have to go to the U.S. Supreme Court.
The attack on bail, is this something that's happening nationally?
Absolutely. And
where's it coming from? Why?
Well, hard to say. Really, about 5 years ago, they got an infusion of money from George Soros and other foundations. And at the tail end of the prior Obama administration, Eric Holder sort of joined the party. And they just did a better job of coming up with the narrative that he's rich and he's poor, and that's not fair. And that's really kind of the centerpiece of what they're arguing.
Mark, you've talked about this one before with us. Jump in here.
Yeah, Jeff, the San Francisco ruling, it's already in effect that an injunction was going to require San Francisco to adopt new rules. But they already had the typical California rule that there had to be a hearing within 48 hours. Isn't that correct?
That's correct, and the judge still hasn't entered the injunction, and I don't know what the delay is, but there's some fight over the scope of the injunction. So technically, it hasn't been entered yet, but she has indeed declared the bail schedule unconstitutional.
And she's part of the Ninth Circuit, I'm assuming?
She's a U.S. District Court judge for the Northern District of California, and I believe her name is Judge Gonzalez-Rogers. So
potentially, based on this Georgia ruling, she could follow this Georgia ruling and say there's no problem as it exists in California, correct?
I believe so.
Yeah, it's pretty interesting, Ray. There's a Georgia ruling. There was a man who he's a homeless guy. He was taken in for some minor charge of I think drunk in public or something. He was ordered to pay $160, the bail was $160, and he said I can't afford it. And like I've always said, you have 48 hours to see a judge, and that judge is supposed to make a ruling based on your financial hardships and things and your financial, status as to whether he could ensure, number one, whether the public's protected and whether you are going to return. And if he says, listen, you are indigent or you have low income and I'm going to only assess $5 and that will assure you to return, then it's already in place. We've already been doing it. It's throughout the United States. It's pretty much the same. And I think Georgia and the Court of Appeals over there basically said, hey, it's perfectly fine. We don't have to do anything. So it's pretty interesting.
The background on this Georgia case, Jeff, the origination of that, and how did it get to this point where the Supreme Court finally had this dropped at their front door and kicked it back?
Well, the first of the cases, started in a Walmart parking lot during the Obama administration when Eric Holder jumped into Varden versus City of Clanton, and then there were a bunch of settlements, a bullying of small cities, and eventually the city of Calhoun, Georgia, decided enough, was enough, and decided to take up the fight. And of course, that was 3 years ago when we got involved, hired former U.S. Solicitor General Paul Clement to file a couple of briefs in the case, and this was the first case that was really challenged and went all the way up, and it took 3 years to finally get there.
Are there any other municipalities, states, whatever, who have gone down this road and done away with bail, Jeff?
Really, it's New Jersey, and I think to a certain extent New Mexico. New Jersey, they implemented January 1st of 2017. They finally released some numbers, and there's some debate as to whether it's been a success or not. And really whether the system of, preventative detention without bail and release is a better system than having bail in the middle, which is what, is supposed to happen in New Mexico. New Mexico's been a problem because it was done by court rules, and the prosecutors just can't keep up with it. So you're tending to see a lot of dangerous people getting released when they probably, under the architecture of the system, would have gotten detention.
Great.
Yeah, I understand even New York tried to pass or is passing a bill for nonviolent misdemeanors and felonies to eliminate the cash bail process.
They are. And interestingly, there was some proposal to move to dangerousness and preventative detention, and that was completely, rejected by the New York legislature again, and has been consistently since 1965.
Yeah, what's happening is that a lot of these courts, and I got to say, it's more of a left side thinking is we are going to start decriminalizing everything that is considered a misdemeanor or quote unquote nonviolent. The problem is the misdemeanors and the nonviolence are many times drug charges and charges that have as part of the support system for the drugs in the United States, a makeup of very, very violent offenses. So when you start decriminalizing all these things and releasing people, then what happens is the more violent offenses also become less important, decriminalized in many respects, or you never get to those more important offenses. So.
Let me ask you both, and Jeff, you can start with this. If not bail, what? What is the alternative that these other areas are doing or looking at, and what does California want to do if they're successful in getting rid of it?
Well, really, it's the federal system. It's the Washington, D.C. system, and now the New Jersey system. Thought once to be unconstitutional by many, including former Justice of the U.S. Supreme Court, Thurgood Marshall, who dissented in the case. But really, it's locking people up without bail, giving the government the power to do that, and everybody else gets a release. And has supervised by the state. And so the federal system, I think, is really the architecture of what Senate Bill 10 was and what happens to be the alternative. And I would say there are other alternatives without blowing up the whole system, such as, what New York's doing, or cite and release policies, don't arrest people that are going to get out anyway, and those types of reforms. But really the big reform is to blow up the whole system and go to the system of preventative detention and using the risk algorithms to help aid those decisions.
And the way you're describing this, to my limited understanding of how these things work, that sounds unconstitutional on its own.
Well, I certainly would have reversed U.S. versus Salerno, but Chief Justice Rehnquist at the time and 6 other justices thought otherwise.
Well, I think part of the issue also is that the federal system has so fewer cases than a typical California Superior Court system does, that we are barely able to watch people on probation with this whole realignment. And the probation department is so overloaded that what you're in fact trying to do and California is asking to do is to impose a whole new bureaucratic system that is going to be just as bloated and overworked as all the rest of them. And when you have a perfectly decent system right now, and that is go before the judge, plead your case, and if he finds financial hardship, he could lower the bail.
Let me grab some phone calls from the audience. Carl, go ahead. You're on KMJ. Hi.
Thanks, Ray. I hope you're feeling better.
Thank you.
I have a question for the bail guy. The bail is just to procure appearance, but a person could go in there and sign their own signature for the bail. The bail is just you can do it on your own. Why do we need you guys? And like an infraction, they put it in California where you had to put bail up. I had an infraction case. I went in there. They wanted $400 bail, and I'm like, this is not an arrestable offense, so I should not have to put up bail. So why would I have to forfeit bail on this stuff? And then the bail officers, they just put up their signature on a bond. They don't actually put the cash up, and then that bond is insured. So where is their loss if nobody
So you're saying that they're basically unnecessary, that third-party activity of the bail's bondsman.
You go into court, you tell the judge, I'll appear on my own bond, I'll just sign my signature to show up, and they have to accept that. These bond officers are getting 10%, 15%. They don't actually put the cash up. They just put up a bond that you can do on your own signature.
All right, Carl, let's get a response.
Yeah, Jeff, go ahead and you can tackle that, Jeff, because he has some things right and some things not quite right. So, Jeff, go ahead and tackle that.
You got it. So if you're released on your own recognizance, you're signing a bond that you're going to return to court and abide by the standard conditions. So in many cases, you're allowed to do that. When it comes to financial bonds, you do have a choice of putting up your own cash or a third party putting up their own cash, which they can do. The bail market in California is really competitive, and so that's why a lot of people use a bondsman, and it's also why the bonds are pretty high, because sometimes, in other states, a bondsman may get 10%. In California, it's much less. A bondsman does not, you're right, put up the actual cash, but they're backed in California by insurance companies that are licensed by the Department of Insurance, and so they have to pay those losses when they occur. And of course, if a bondsman puts up 5 to 10%, or puts up 10% to the court, or takes a 10% premium, if the person doesn't return to court, they forfeit the entire 100%, and so that's where the incentive comes in. So,
and what
there's kind of three types there.
Yeah, and what you have to understand, the what he's talking about, just signing a paper, is on very, very minor things. You could just sign as a promise to appear, and the judge will say, I trust you, you don't have any priors. But when we have cases where there's a lot of priors, or there's a very serious crime, and there's a risk that the guy's going to flee, you could either put up all of the money, which most people don't have, or there's these nice bail bondsmen out there that will say, I will take a very small percentage, I will put it towards my towards my business, etc. I have a bond of $1 million that I will give the court, that if you take off, I will give them the cash that you promised, but I'll put up you give me just a small amount. And I've seen them late at night because there was an office right next to our office. They are up at all hours of the night searching out people that have skipped on the bail. The government does not have the resources to do that. And this private financial business that these bail bondsmen have are the perfect way to do it. They will go and they will find you and they will take you back to court because they're going to lose money if they don't.
Gentlemen, if you'll hold on, we'll take a breather here. We'll come back and just spend a few minutes more with Jeff, and I might hold Mark over for some other stuff. But phone calls, questions, comments, 490-5858. And from anywhere in the state of California, 800-776-5858. Do it to it. We'll return in just a few on News Talk 580, 105.9, KMJ, the Ray Appleton program. Stay put. Back at you here at KMJ. Joining us via the telephone is Jeff Clayton, who's the executive director of the American Bail Coalition, and here in the studio, defense attorney Mark Capitan. We're talking about the U.S. Supreme Court denying a particular case that they didn't want to hear, and in doing that, it upholds the use of bail money and bail schedules as being constitutional. And of course, here in California, we have a battle that's going on. It was shot down once, but it could come back again, and that's the elimination of bail. And it's something that we've talked about before on the program. And there's one component of this that I like to bring up. It's a real obvious one, Jeff, and that is, if California did away with bail, what becomes of all those individuals who are in that business?
Well, they go looking for other jobs is what they end up doing. Maybe they move to other states, but probably not. Most of the bail agents in California love California, and I don't see them moving to, Mississippi, Tennessee, etc.
And I would assume this state has got a lot of individuals in the bail business.
Yeah, we estimate it's probably total, workforce jobs. You're talking assistants and part-timers and all that sort of thing. We're thinking it's probably in the neighborhood of 15,000 jobs are supported by it.
Jeff, let me clear up one thing. Did the bail issue actually pass? And you guys have an injunction or a lawsuit that was filed, and it's on a stay at this point?
No. So Senate Bill 10 passed, and we launched a referendum drive, obtained the 380,000 signatures, and so the voters will vote on it on the November 2020 ballot.
Okay,
yeah,
I get it. Okay, so it was passed by. I get it. Okay.
Yeah.
Wow.
And if that indeed passes via the voters, what have you done any polling on that? What's the vibe, Jeff?
We're in the process right now. The campaign people told us that there was a lot of enthusiasm at the grassroots level, really against two things. One, that we're going to use this algorithm, and it's going to be the primary driver, to put people in the low risk, medium risk, high risk. And then the second thing was really preventative detention. That's what flipped the 50 civil rights groups against this. Because to say that, we're going to give the state of California greater power to lock people up, and that's going to result in fewer people in jail just doesn't, pass the test of history or really pass the laugh test in my mind.
Well, under what you're proposing, is there a right to immediate bail?
There really isn't if you're in medium or high risk. If you're in medium, you're going to get released, but you're probably going to have to be assessed first by the algorithm, and you're going to be supervised, and all the supervisory conditions are going to be paid for by the state. So judges are going to put wide swaths of people on ankle monitors and that sort of thing because there's no bail. And then if you're high risk, obviously preventative detention hearing, and who knows how long that's going to take. It could take, and I think under the rules, at least under the statute, it could be with a continuance of up to like 10 days before that hearing has to happen.
One thing I want to point out to the audience, and Mark and I talked about it in the commercial break, Mark is supportive of keeping the system status quo. But if it flew in another direction and there were no bail, you'd actually make more money, wouldn't you? Yeah,
absolutely. It kills me every time that I come in here, and I'm supporting keeping the status quo. Number one, I like the status quo because that's how it's always been. I think it's a fair system. I think it's a system that is also sound in preventing the government more intrusion into our private lives and things of that nature. And it's a private system that works. The problem is that money, typically when a person's arrested, the first thing they think of is how do I bail out, not how do I get an attorney. If they have the new bail system, then all that money gets saved for me, and it's gonna dramatically change where people spend their money when they get arrested. So. But I think it's the wrong thing to do. I've always said if it takes money, out of my pocket, if I think it's the right thing to do and constitutionally the right thing to do, then oh well, so be it.
Jeff, in wrapping it up with you, what final words would you like to impart? Tell us about the organization if anybody wants to find out more, all that good stuff, sir.
Yep, go to our website, ambailcoalition.org. You can read all about it. And I think look for us, next summer is when the big drive will happen, and we'll see what happens. And hopefully, in the meantime, our friends in Sacramento will realize that maybe this is a bad idea, and we can finally make a deal that works for everybody in California.
Right on, right on. Hey, thank you for your time, Jeff. I appreciate it very much.
Thank you. Have a great weekend, guys.
All right, you too. Take care. Jeff Clayton, again, who is the executive director of the American Bail Coalition. Spit it out, Ray.